Hello and welcome. My name's Kevin Igoe, Managing Director of PFP. I'm delighted to be with Mark Taylor from Buzzacott today for one of our monthly webinars for our member firms and selected guests, and you're all very welcome. Though we will be sending out copies of the slides after the presentation. But the presentation itself today is covering something we're seeing more and more of, i.e. HMRC's increasing use of undercover test purchases, where they go out at the taxpayer's expense and have a few beers and some food, and then go back and visit later on. So first of all, let me introduce Mark Taylor. So good afternoon, Mark.
Good afternoon, Kevin, and good afternoon, everybody.
Perhaps you could let our listeners know a little bit about yourself and your background.
Okay, I'm currently the head of the tax investigations team at Buzzacott. Prior to that, I've been in private practice now for 12 years, and leading up to that, I served in all of HMRC's elite investigation offices and was an HMRC officer, and prior to that, an Inland Revenue officer for 20 years.
And before we go on, just to say congratulations, because you won the Tax Investigations Team of the Year award recently at the Tolley's Taxation Awards.
Yes, we did. Thank you very much. It was a bit of a messy night, but yeah, it was a fantastic achievement. So thank you for that.
Okay. So without any further ado.
Okay, picture the scene. You're at a family wedding, leaving your restaurant in the hands of your staff. The first call you receive advises you that your EPOS till system is down. Now, Saturday night is the busiest night. Without it, you'll struggle to cover costs. The decision is taken to open with a sign saying cash only tonight and advise customers as they arrive to be seated. Later, second call advises that it's been a poor night. A few weeks later, you receive a visit by HMRC. They ask to see your records and concentrate on certain dates. You are then told that the take-ins are believed to be inaccurate and that you're suspected of having off-record staff. You naturally challenge this and are told HMRC have made covert purchases and an eat-in at your restaurant. You are eventually given the dates and find the inaccurate take-ins belief primarily comes from that very evening when cash had to be taken because the till was down. You explain that you suspect staff theft. The off-record staff comes from visits when your son helped out, and primarily because HMRC have scaled up your business take-ins, and therefore naturally you're going to need more staff according to them. You are denied access to the officer's visit notes. You then receive a flood of brown letters containing assessments and determinations in excess of £250,000 and accused of deliberate and concealed behaviour with gargantuan penalties. Ladies and gentlemen, this is not a made-up case. This is not an exceptional case with unusual HMRC practices. This is HMRC's increasing use of undercover test purchases and eats. Now, the areas we will cover today should hopefully provide you with the necessary information to allow you to best advise and, dare I say it, best protect your clients, particularly those who have the audacity to be cash traders. Hopefully, you will be enlightened by the official and unofficial reasons why HMRC conducts covert surveillance activity. You should also find the case studies that HMRC refer to and those that they do not revealing, as they indicate the extent of HMRC's activity in this area and some concerning incorrect findings. Forewarned is forearmed. Now, clearly, by a person not knowing their activities are being observed or monitored, behaving in the way they normally would do is of great use and a vital intelligence source to HMRC, particularly if the subject is engaged in non-compliance. In my former life, Kevin will love to hear this, but I myself have been the benefactor of many a Chinese or Indian meal, and dare I say even a cheeky pint or two at the taxpayer's expense. Kevin, you'd be delighted to hear that I mastered the art of covertly eating poppadoms for HMRC. Whilst many people would naturally think of test purchases or eats as covert surveillance, HMRC is monitoring platforms such as Facebook, Instagram, eBay to identify non-compliance, and this over a sustained period can be covert surveillance activity. Now, HMRC must justify its use of covert surveillance activity to identify non-compliance by meeting the criteria shown, particularly the necessary and proportionate, and that there's no other way to obtain the information. Test purchases and test eats in advance of an insurance visit to HMRC provide useful information from within the very heart of a business premises, and purchases and eats allow HMRC to then test the reliability of a trader's sales record and takings figure.
I have a quick question from Tom. Tom's heard that they have been, certainly a number of years ago, taking videos of customers going in and out of a shop. Are you aware that they're still doing that?
The photographing of customers, that would only, there's three forms of surveillance that I'll come on to, but that would be, for me, directed surveillance, and that's sort of overseen by the by RIPA, which is the Regulation and Investigations Act. That requires a high standard of authorization. So you may have officers, Kevin, that are, dare I say it, flying outside of their powers in doing that. It would have to be directed surveillance for them to do that, and authorised for them to do that.
And who would authorise that for them?
It would be a senior HMRC officer. They wouldn't have to go to first tier tribunal to do that, which is more worrying. But like I said, in terms with today's smartphones, it would be very easy for an HMRC officer to, dare I say, go off radar and video in such a way when really they shouldn't be.
Chairman queries, how does this fit with your human rights and invasion of privacy, GDPR?
Well, that has been beautifully set up for the next slide. And in terms of the coverts of, I mean, the whole thing about the human rights is HMRC recognises it does breach human rights, but provided that breach, as I'll come on, actually it's not this slide, it's one a bit later. If HMRC believes that it will lead to the recovery of loss of tax, then they're prohibited, or they're permitted to do it. Sorry. Right. Covert surveillance is authorised by HMRC themselves, and in my view, HMRC are not held to account. They invoke the exemptions of the Freedom of Information Act 2000 over their covert surveillance activity, like Tinkerbell sprinkles her fairy dust. If you ask for HMRC's notes of purchase eats and test eats, and you'll be told by releasing them, it would or be likely to prejudice the prevention of crime, the assessment or collection of any tax, or of any imposition of a similar nature, or the administration of justice. That's quite a difficult thing to receive when, for example, you're head of a tax investigations team like myself, and you're told by HMRC that by giving it to us, that it's going to basically prejudice the prevention of crime. However, appeal assessments, if you do appeal assessments and go before the tribunal and there's a direction for them to be issued, you will be served them. Now, quite frankly, I find this approach and the fact that you've got to go to tribunal to get these notes, I just find it ridiculous and unfair and in breach of HMRC's own charter and promises to its customers. It's important to note that HMRC recognises that surveillance activity interferes with a person's privacy under the Human Rights Act, and as I indicated earlier, HMRC considers that breach is fine and that interference is fine if it assists establishing a person's tax liability. Now, If you desire private information, then this is directed surveillance, and this requires a higher conditions of authorization under RIPA, which, as I said, the Regulation of Investigating Powers Act. Now, private information is anything to do with a person's private or personal relationship with others, and it also includes family and professional or business relationships. Now, there's two main conditions that have to be met for covert surveillance to be used. Now, necessary is because it can't be obtained in a less intrusive way. Proportionate is because of the potential tax yield it's likely to result. Now, the authorized officer is sent a request for agreement, and within that includes a brief description of the business and its compliance history, the nature of the risk and the potential tax yield, the information that the officer needs to obtain from any visits, when and how the officer intends to carry out the surveillance, why the risk can't be addressed in a less intrusive way, and any previous covert activity on this person or business, and the estimated costs. Now, visits can be authorized for days, weeks, and months, and I think it would be fair to say that in the past, the visits were of a longer duration than they are now. And and what you'll see is that HMRC has taken cases to tribunal, or the cases and challenges have been made where over the period of time there's been less and less days that have been spent on these visits before challenges are made. And one can argue that is primarily, I would say, down to cost cutting. And clearly, if you're going to face a challenge for HMRC having just visited your premises for one day and then challenge you for the last 6 years plus, it's somewhat tough to take, and dare I say it, the likelihood of those challenges being wrong are more increased.
Okay, I have a few questions coming in. Fires talks about what procedures do HMRC take in obtaining authorization to enter the various platforms such as Facebook and eBay?
Well, in terms of if it's what is called a basic check, then they don't actually need authorization. So if they something basic, we will come on to this, but something basic is sort of almost like it's where there's not a regular sustained pattern of visits, they wouldn't need for authorization. If there is a more regular monitoring, then they would need authorization. But the level of authorization is much less than if it's directed surveillance, which is where they have to, because they're then having to conform to RIPA, if I can again call it that.
Okay. Alex asks, you mentioned that you don't have to, that they won't necessarily show you the observation notes, but do they have to show you what authorization they've been granted?
No, they won't show you the they won't show you the authorization, and again, because of the fact of they will invoke the exemptions under the Freedom of Information Act. I mean, for example, there's this one wonderful section in on the Compliance Handbook. It's actually Compliance Handbook 207515, and that is the disclosure of the officer's covert activity notes. I would ask everybody to perhaps have a look at that. So it's Compliance Handbook CH. If you just Google CH 207515 and look at that, there's nothing on it. It's just the whole text is just withheld under the Freedom of Information Act. Only HMRC officers internally can access and view that.
Okay, Lisa asks the question, why do they need to drink alcohol at these visits?
Well, I always felt the need to do that, Kevin, if I've been brutally honest. One, because curry never tastes the same for me without a Kingfisher. But secondly, my argument was always to blend in. So that there has been occasions, for example, where we've gone in, as part of my former life, I served in a surveillance team, and we got asked to go into a particular public house, and I had so at the taxpayer's expense, I sat at the bar drinking lager and clicking for every pint of lager that was served in there. Now, obviously, part of that is to blend in. If I perhaps sat in that pub drinking, dare I say it, J2Os for 4 hours, I might in an East End pub, I might have stood out a bit, just possibly.
Okay. Another question here from Rebecca. Do HMRC have the experience training to understand the running of the business and come to the correct conclusions?
In my view, no. I think, again, I come on to this later, trying to ask a civil servant to, and particularly, dare I say it, there's a new breed of cadet inspectors that have just that are come out of university and have led an extremely sort of, dare I say it, a sheltered life. Then go into the fast track, and next thing you know, they're challenging commercial entrepreneurs with regard to their business economics. So it's you know, there are some officers that are very, very good at putting together because of experience. There's others that they're not. But any business economics exercise by HMRC really does need to be challenged.
So do you not feel it's just about collecting the right amount of tax?
I'm not sure how you can say that with a straight face, Kevin.
Okay, fine. Let's move on.
Okay. So the 3 levels of or covert activity. Obviously, I've sort of alluded to those in some of the questions, but you know, people should be aware that there are 3 levels, and everybody should be familiar with each. Now, as you go, you know, the basic fact check, as I've said, requires a sort of no authorization, and then as you go through them, they then require greater reasons and conditions to be authorized. The directed surveillance is the key one, and you need DSA authority for that to take place.
Someone's come back on the authorization.
Yeah.
That they're not allowed to, that they don't have to show it. Would they have to show it at tribunal? Because if not, it would seem that the taxpayer, the customer, has no protection whatsoever against the revenue basically doing whatever they like.
Yes, I would. That would be one of the documents that we seek from HMRC, because clearly in that they have to, you know, as you can see, they have to show why it's necessary, and they have to show why by doing so it's the only way of obtaining the information. So yes, without any doubt, you need to insist that is served along with the notes of the visit.
Paul just makes a comment as an aside. His granddad was subject to a covert operation in the 1950s. He worked out he was being watched as the taxman was reading the newspaper upside down.
So, yeah, yes. Well, yeah, okay. Well, that says everything. They were probably wearing a bowler hat as well, no doubt, wasn't they, doing so?
I mean, we did have a case where the notes were shown of the observation, and in it was shown that each of the officers, there were 2 of them, and they had like 6 pints of lager each during the course of the night. And the revenue withdrew the case because the accountant made the point, well, you were obviously drunk. How can you possibly rely on your own evidence? And they actually produced their report to say, yes, we had 6 pints of lager each.
Well, one of the things I would say is that obviously when they're in there and they're having a meal, that's the one receipt that they're clearly looking to find when they go in to later look at the business. It's always interesting, as you say, to actually look to see what they've had when they've gone in there. Because clearly, if they've gone in there and dare I say, decided to have a bit of fun and fill their boots at the taxpayer's expense on the alcohol side, then yes, as you say, it's something that you can use to challenge. Okay, so In terms of the basic fact check, as I've mentioned, this requires no authorization and is generally done to get a greater understanding of a business. Now, show my age here. In the past, this was something that was done, and it was done quite regularly. But in terms of the walk or drive-bys, just to get a feeling of what the business looked like and what you were dealing with. But I have to say now, my investigation team at Buzzacott have found that HMRC has become more reliant on Google Street View, and moreover, the fact that Street View gets updated. So HMRC is able to then look at the historical images to see how a property has changed over the years. So again, that is something to be alive to in terms of what Google Street View actually shows for your clients. Now, this is the most common used surveillance activity by HMRC and is referred to as OBS, OBS. Now, the intelligence obtained from OBS is then used to test a trader's prime statutory records and accounts, including HMRC performance business exercises. Now, somebody said something earlier, a question came in about the reliability of the accuracy of an HMRC officer doing business economics. I have to say, as a former senior inspector myself, I always thought my case was never the strongest if I had to rely on business economics. And maybe part of that was from an incident I had when I was a junior inspector, and I went to a meeting with a senior inspector, and it was a fish and chip shop proprietor. And the senior inspector was alleging that there were undeclared take-ins. And one of the questions, this was obviously denied by the proprietor, and one of the questions was wastage of a potato. The proprietor claimed it was about 50%, and next thing I know, my senior inspector pulls out a average size King Edward, and then a potato peeler and a knife, and then in front of the proprietor, peels the potato and cuts it into chips. So that's the sort of way in which sort of the HMRC mindset thinks. Now, regrettably, whilst done with the best of intentions, business economic exercises have led to unrealistic, disproportionate and uncommercial accusations being made by HMRC. How HMRC can rely on notes of its OBS to then recalculate a trader's take-ins and profits and not provide these notes unless under tribunal direction is a travesty. It should also be noted that use of digital devices are permitted, but the instructions to HMRC officers say for directed surveillance it's different, but for your covert surveillance to observe business activity, it's really restricted to just taking a copy of the sales invoice. It doesn't sort of extend to taking photos of people and customers.
A couple of questions, Jez. Can observed parties be used in calculations for additional sales?
Should I say that again?
Can observed parties be used in calculations for additional sales? So I guess they look at the individual parties, groups of people.
Oh yeah, no, without doubt. What they do is whilst they're in the restaurant, they're there not just necessarily to have a meal and to have a chat and a catch up and then go back into that business later on with that receipt. What they're doing is they're looking not only at what's been ordered in and around them, they're also looking for takeaways and, for example, Deliveroos that are coming in and being collected. So, even things in terms of the atmosphere, they're looking at how many people are ordering wine, I mean, it's a counting the numbers of people there. So for example, a good one would be if they're in a pizza establishment, they're looking to see what is the average table, what's the sort of size of pizza people are buying, to then allow them to calculate their business economics.
So you had to drink wine as well as beer to fit in, did you?
Yes, I did.
You were a martyr to your cause, Mark.
And cocktails, by the way, as well. I just, I took my job very professionally, Kevin.
How can observations be disputed when the observations may be years ago and the business owner cannot recall what happened on the night?
Well, obviously, the first thing would be that there's a natural period in which one is expected to keep records. Typically, what would happen is the test purchasing eats are done in advance. I would say the vast majority of occasions they're done in advance of a subsequent visit. It's data gathering to allow them to know the establishment, know the proprietor, know the business and the customers far better in advance of then going in and doing that assurance visit. So yes, it may well have been watched over a period of time, but we should not be talking years and years ago before then a challenge is made. It may well be years and years before you end up in tribunal, but the challenge should come within a reasonable time.
Okay. Another one, Fayez. Where business premises have video cameras, can these be used in some way as evidence if the owner was smart enough to pick out a suspicious customer?
In suspicious, I wonder, are they alluding to me drinking my cocktails in my former HMRC life? Yeah, I mean, obviously, I think the thing to bear in mind you're absolutely right. I think there's a number of establishments, we act for restaurant clients, and yes, particularly now, not only are they filming sort of they're filming inside the restaurant, but they're filming specific areas, which tends to be in and around the till area. Now that's one area for me where I don't think HMRC has necessarily pushed on in obtaining that data and that evidence to actually then challenge.
Yeah, I mean, the other side of that, I have seen a case where the client used the video to challenge the numbers that were in the restaurant.
Absolutely, yeah, that would be good evidence without a shadow. Okay, this is the most intrusive of surveillance by HMRC, and it is more excuse me, it's more commonly and typically used by HMRC fraud investigation service. It has to be authorized under RIPA, and this type of surveillance activity is clearly the most intrusive that you can get. I mean, particularly in terms of recording conversations. It would be unusual. I mean, for this sort of activity to take place, there would need to be very good reasons. It's more likely to be used in the case where perhaps HMRC suspected criminal activity and it started as a criminal investigation and perhaps has then gone back to a civil investigation.
All Oscar chains reviewed, as he chains of shops and restaurants.
Yes, there's a case that I'll come on to, which Angel's Beauty Parlour, which is a recent case, and dare I say it reminded me of my days drinking cocktails at the Crown's expense, and they went to that was a very organised activity, covert activity, where they visited salons across the country.
If you suspect you have an undercover HMRC officer on the premises, can you ask them to leave?
Yes, you can.
You can ask any customer to leave.
You can, but yes, you can. I mean, what I would say is that the you're not going to see them there with a suit, and bowler hat, and umbrella on, looking like Hector, the taxman. So
presumably they'll be the only ones with a pint of beer, a bottle of wine, and a cocktail in front of them.
quite possibly, Kevin.
So they blend in.
Yeah. The as shown here, this is sort of like what I'd call the typical non-RIPA authorized covert surveillance activity that are used by HMRC, and that they feature in the case studies. Now, generally, small team of officers are sent to target premises and make purchases of meals, and to observe waiters and other staff to see what happens to the money, what procedures are operated. The officers thereafter complete a report, sometimes a witness statement, which typically details what they purchased. And obviously a receipt is an essential feature of this. And obviously, whilst Kevin and I have sort of made reference about alcohol being purchased, that is something to look for in terms of the credibility of those particular officers, what the cash taking routine is for the business, and what the waiter does do with the cash or credit card slips. It's interesting that sometimes they'll leave a cash tip to then follow that up to see what happened with that cash tip. The numbers of diners in the restaurant between certain times, and the atmosphere of the restaurant. And this type of activity can go on for several days, and if the business and suspected misdeclarations are large enough, it can go on over a period of weeks. The output from this type of activity gives a rough idea of the level of takings for the restaurant for a given period, and by extrapolation, an idea of the actual level of takings for say that period or an accounting year can then be ascertained by HMRC.
Okay, before we go on to the case studies, Sandy, you've asked, you mentioned about restaurants, pubs, and the like. What other industries, stroke business types are routinely investigated in this manner, and can you shed some light on the style of investigations undertaken?
Well, generally it is for cash trades. They're targeted more and more than, dare I say, any other trade. So you are looking at restaurants, bars, now hairdressers, beauty salons, particularly ones where kiosks, places in shopping centres, market stalls, all those sort of businesses are likely to be targeted. Generally, what tends to happen is you'll have the series of these visits, generally all covert and unbeknown to you. Then you'll receive a VAT, potentially a VAT assurance visit. That's the one that makes more sense because it gets HMRC in terms of the indirect, and there's more joining up between indirect and direct taxes. But it's the indirect that's the opportunity to get into the business a lot earlier than it would be for direct tax. And obviously, and armed with this information, HMRC goes in for the assurance visit, and they're looking for particularly on the occasions where there's been the visits, to sort of look at the tie-in between what was observed and what is now recorded. So if you have a client who is a cash trader, you receive notification from HMRC that you have an assurance visit. Please do not underestimate that your client may well have, unbeknown, had purchase or test eats ahead of that visit. Very important.
Walter asks, are surveillance activities mainly as a result of suspect figures in accounting and VAT records, or are they done at random based on the risk of type of outlet?
Both. They're also done, dare I say, through intelligence. the and specific, for example, if there is examples of trades that sort of open and shut, a particular restaurant that opens and shuts and seems to be involved in suspected Phoenix, then that's a likely trigger for HMRC to try and get in there when the business is actually live.
Mohammed asks, is this limited to direct tax and or VAT, or can it go on to pay as well?
No, it's the challenge tends to be is that they look at both things, because if you well, I think Kevin, you and I were talking about this before we started, that if they then work out or they calculate from their business economics that you're achieving by their calculations a certain level of take-ins, they'll then look to see whether or not it's achievable for the staff that you've had to be able to achieve that. Now, they'll also look at clearly the numbers of employees that you had when they've done those visits. So it would follow that you could have from an unknown covert visit, you would have a challenge on your VAT, your corporation tax or income tax, and pay as you earn.
Okay, thank you. Simon mentions about market traders. Is there anything additional to point out in respect of market traders being observed?
Obviously, it would be more difficult for HMRC to observe in terms of, dare I say, in a restaurant, you can be there for 2.5 hours and observe. It's a lot easier to observe something when you can go inside a business premises, sit down, and masquerade that you're a client. It's a bit more difficult from a market stall. But ultimately, what you're then looking at is you are looking at either walk-bys, looking at numbers of people, what people are generally buying, and also you would be making specific purchases as well to check that those then are in the records. The other thing that you're more likely to do is probably pay by cash to see whether or not that then, because then it's almost like temptation. If you go to a market stall, buy a specific item that's perhaps unique in price, give cash, then obviously there's a temptation there to see whether or not that trader puts that through his records.
Samuel asked about the observation notes and if they're not handed over. And his question is, in the event they're not handed over upon request, are we better off simply asking the revenue to raise an assessment, list it for tribunal, so then they'll have to give us the notes?
Yes, as I would, it's not something that I think, it's not the right answer, Kevin, but yes, that is the answer.
Yeah.
In other compliance checks, you wouldn't want that to happen because you'd want to avoid that position. But unfortunately, here, that is something that would perhaps need to happen.
Okay, fine. Let's move on to our case study.
Okay, so in terms of the case studies, these are the ones that are actually listed by HMRC. I'm not going to go through every single one and exhaust them, but I thought what was quite useful was to explain to you that in the first 4 shown on these bullet points, they were all found in HMRC's favour. The last one wasn't. I'll come on to that. But essentially, the assessments were upheld in full on all 4. Now, the first one involved officers with 6 visits. And I think this is the thing that I want to bring out in this, in terms of the level of activity of which then the receipts of the visits have then been used to recalculate HMRC's figures for them to challenge the accuracy of the business records and declare take-ins. So the first one involves 6 visits that were done over just 1 week. Tuesday to Sunday, so the only day they didn't go in was on a Monday. So 1 week's challenge, 1 week's monitoring, and then a challenge. The second one involved, that was again 6 visits, but that was 2 weeks of challenge on a Friday, a Saturday, and a midweek day. The third one was done 4 visits, but that was whilst the business was open for the whole period. So there you would have a shift of officers coming in. So for example, the business opened at say for lunch at say 12:30. Someone would be in there smack at 12:30. They would be there till 2 o'clock, and just before 2 o'clock, the next 2 officers would come in. Now, one of the things that is always looked at as well is in terms of those 2 officers. If you've got 2 officers there, one of the things that they have to do is they have to draw a sketch and floor plan to say where they were sitting and to demonstrate that their vision was not impaired. They've also need the 2 just in case nature takes over and one of them has to go to the toilet. They're still there. One of them is still there monitoring. The fourth one, this actually was 2 days. So we've come down, and in there, the main reason actually why that particular business sort of fell on its sword is because after the assurance visit, so there was 2 days of observations, or OBS as HMRC likes to call it, followed then by the assurance visit. And at the assurance visit, following that, lo and behold, the takings suddenly started to go up. And as a result of that, HMRC then went back on a second assurance visit, noticed this, and that really, for me, was the thing that sealed that case, more than the actual 2 days observations. Now, the last one, what was quite, that actually was not found in HMRC's favour, and it's a bit surprising in some extent why it's actually featured by them. Now, and the main reasons for this was because it was actually found that that when the sketch that they did of the floor plan and where they were sitting was inaccurate when it was in the proceedings. It was shown to be inaccurate. And the second thing about that is where they were actually sitting, it was shown that their vision would have been impaired. So by that, it was held that the ops and then the notes from that and the findings from that couldn't be relied on.
So on those slides, I've had a couple of queries. One, that do the references LON, EDN, and MAN stand for the UK cities where the traders were located?
Yes, correct. Well, or where it was held. So, for example, the EDN is Edinburgh, MAN Manchester. Yeah, correct. So the 2 cases that aren't actually listed by HMRC, and they're more recent. Now, the first Morella, this was part allowed. So obviously so assessments were appealed and they were allowed, as I say, in part, and they were varied by the tribunal. Now this came from 1 whole day of OBS. So hopefully, so what we're sort of what I believe we're starting to see is less time taken by HMRC to actually conduct their activity. When we're coming right down now to a very basic 1 day. Now, the appellant's case here perhaps wasn't the best guided because their emphasis on the challenge was more on HMRC's good faith, and their alternative calculation wasn't actually based on detailed information about the company's business. So in many respects, they sort of shot themselves in the foot. Now, the first tier tribunal actually expressed concerns about HMRC's figures, but based on the evidence in front of them, particularly by the fact that the appellant hadn't actually put forward differing figures, and sort of that could be substantiated by the company's business, the HMRC really only had the HMRC's figures to really work from, and on the evidence they found that there was an overstatement by HMRC of 19 transactions, meaning therefore so the very prime evidence that HMRC was relying was inflated. So by virtue of that, and that was just so there was no real thorough further analysis of HMRC's figures. It just literally was that when the tribunal judge added up the visits, he found that there were actually 19 fewer than what HMRC had alleged, and therefore by extrapolation it meant that the assessments had to be reduced. So I mean, this case for me shows that HMRC's calculations do have flaws, and dare I say it, the merits of good alternative calculations that need to be supported.
If you suspect you have an officer, is it sensible to sit them at a table where they can't see the till?
Yes, but if I was a trader, I think I'd have a special table in the broom cupboard.
How about a car dealer previously caught for fraud? Is it likely they'll carry out covert operations a few years after settlement?
I would not be surprised. The car traders in particular are I mean, there was one particular area where I was stationed as an HMRC officer, and we probably had more car dealers than most, and they were a good challenge, shall we say, in terms of looking at their records and their stock book, etc., etc. So visits to those premises and looking at the stock in particular would be of vital evidence to cross-check that with the stock book records.
Well, I think it's probably true to say that it wouldn't normally be a few years; it would be shorter than that, wouldn't it? It's probably about a year or so they'd come back. They wouldn't let them do it for,
quite possibly, yeah. So the last case I just wanted to refer to, this is actually a 2019 case, and when the report landed on my desk, it sort of just obviously brought back memories and sort of just re-emphasized, dare I say it, that even that in 2019 we're just the potential flaws that can happen in terms of HMRC's activity. Now, this actually was a late appeal, so that the actual hearing concerned a late appeal, and it was late. It was looked at by the judge Anne Redstone, who is an excellent judge and is a barrister that I myself have sought advice from. Now, the late appeal was allowed because the tribunal had concerns re obvious errors in HMRC's calculation methodology. So whilst obviously looking for a reasonable excuse as to why the appeal was late, also in the interest of, dare I say it, justice, the judge actually then looked a bit deeper into shaking the tree for the accuracy of HMRC's calculations. Now, this business operated beauty salons in shop premises and some shopping centre kiosks around the country. So this goes to show that HMRC can target a national business. Now, HMRC carried out test purchases and walk buys, and some of the flaws then in their calculations when they challenged was that they basically had it that from their calculations that the salons were open 365 days a year, which wasn't the case. That when they then calculated that and somewhat bizarrely, HMRC only attacked this from a pay-as-you-earn point of view, and by claiming that there was more staff that were off record. Now, when they calculated their pay-as-you-earn figures, no allowances were given for personal allowances. All employees were claimed to be full-time workers, whereas in actual fact, most workers were part-time and their earnings were below the personal allowance. Now, what I'm going to do, if I may, I'm going to read out just a small extract from the publication from the judge on this case, because it's very rare that you see something as strong as this. So it says, the total of supposedly unpaid pay-as-you-earn was unreasonable, even ludicrous. The company's corporation tax returns were not under challenge, yet in order to make these further cash payments to supposed ghost employees, the company would have needed extra income of 2.7 million over the 5-year period, or between 400 and 700,000 pounds a year, all of which had supposedly been passed to employees in cash. This level of extra income would have been extraordinary given the scale of the company's operations. Now, as I said, somewhat bizarrely, it was just the pay-as-you-earn that HMRC were attacking on this case. They weren't claiming that the company's returns were wrong, but clearly to fund the payments to the ghost employees, the takings would have to be wrong. So this case, for me, highlights some of the concerns that we have, that these visits are going on, and from that, officers are sitting down and coming up with business economics attacks that just are completely ill-founded. So, in conclusion, they are a valuable tactic, and I know that from my own personal experience, dare I say it, both sides of the table. Whether or not HMRC officers really believe they're necessary and proportionate, the reality is for an HMRC officer, they work. So if they work and they're going to lead to a loss of tax, that's good enough. I think for me, obviously, if you're a cash trader, you stand way more chance of not just unannounced visits, but these covert activities ahead of a challenge on your returns. And as hopefully I've demonstrated, they're very difficult to challenge just in face-to-face negotiations or outside of an appeal process, because you just cannot get access to the activity that underpins HMRC's arguments. And both sides, I have seen business economics arguments put in front of me, both as a senior inspector and also now here representing clients, and they're as strong as a chocolate teapot. They're just, some of them are just ludicrous, and when you actually meet some of the civil servants, that no disrespect, they wouldn't last one week in business. And hopefully we've sort of alluded to the fact that if you come under this sort of challenge, you need to seek specialist advice, because the whole process to try and combat this is very, very difficult.
Okay, Lisa's got a question on business economics exercise. HMRC has undertaken a visit, put evidence forward, but they've asked the accountant to carry out a business economics exercise to see whether their accounts are correct. What would you advise? I
would rather personally that than put the calculator in front of an HMRC officer. To be brutal, I think personally that is something that I would recommend, because I think there's far more, and an accountant, and particularly one that represents businesses, has got a far better handle on creating an exercise than, dare I say it, a civil servant.
Really, they don't want to get in the position where they're looking to disprove their own accounts, do they?
Yes, I mean, but that said, if you're shaking the tree, I'd rather the accountant shake it, Kevin, than HMRC. And to be honest, I'm somewhat surprised that an HMRC officer would actually say that.
Yeah. Okay, great. Well, thanks for that. I would just mention our UK Tax Investigations Conference that we're running in Moorgate on the 11th of October. Our latest speaker to be announced is Keith Gordon, the well-known tax barrister, who's going to be talking to us about some tax cases that he's been dealing with in practice, and how we can use that in our practical dealings with HMRC. So if anybody's interested in that, please contact us. The address is on screen. We will, as I said earlier, be putting forward a copy of these slides to everybody. So for now, can I thank you, Mark, for coming along and giving us a very detailed and thorough presentation.
Thank you, Kevin.
Thank you for that.
Thank you.
And I would thank all of you for logging in and listening to this today. I suspect we'll be back now in September after the summer to give you August just to put a wet towel around your head and just relax a bit. If anybody would like to speak to us about any of our products and services, the R&D, capital allowances, business rates review, please do contact us. Meanwhile, thank you for listening and have a good summer.
Thank you.